Hello, welcome to Vidu Law Niti. In Hindu law, today let us learn conditions of valid Hindu Marriage Act 1955 according to section 5. The essential conditions of a valid marriages. When a marriage between the two parties, they should fulfill these 5 conditions. They are monogamy. Neither party should have spouse living at the time of marriage. Monogamy is a voluntary union for life at one man with one woman to the exclusion of others. The condition laid down in this class for a valid marriage is one of those conditions, contravention of which would make this marriage valid under section 11 of this act. Any marriage between the two Hindu solemnized after the commencement of this act is void if at the date of such marriages either party had a husband or a wife living and the provisions of an Indian Penal Code shall apply accordingly. In this, let us learn some case. Yamuna Bai versus Anantrao. Here the marriage becomes null and void, where it is a violation of the first condition of section 5. It becomes void ab initio. The apex court observed further that the wife is a void marriage cannot claim maintenance under section 125 of the Criminal Procedure Code. The second condition is a mental capacity. As regard the second condition, it is necessary that the parties to marriage are of sound mind and are not suffering from any mental disability, so as to be unfit for giving a valid consent, and therefore it is laid down in section 5(2) of the Act that neither party at the time of marriage is incapable of giving a valid consent to in it in consequence of the unsoundness of mind or has been suffering from the mental disorder or such a kind or such a extent to be unfit for a marriage and for the procreation of children, or neither party has been subjected to recurrent attack of insanity. In this rare case, Lakshmi Narayana versus Shanti. The Supreme Court observed that the brand of the wife as unfit for a marriage and procreation of a children, it needs to be established that the alignment suffered by her is of such a kind or such a extent that it is impossible for her to lead a married life. The third condition is age of parties. The Act lays down the condition that at a time of a marriage, a boy must be completed at the age of 21 and a bride must be completed at the age of 18. In this, there is a case Sukhu versus State of Gujarat. The State High Court has opinion on 23rd September 2015 that the Prohibition of a Child Marriage Act 2006 overrides the provisions of the Hindu personal law or any other personal law because of the Prohibition of a Child Marriage Act is a special law. The next one is degrees of prohibited relationship. Class 10, if section 5 says no marriage is valid if it is made between the persons related to each other within the prohibited degree unless such marriage is sanctioned by customs or usage governing both the parties. Example, brother's daughter, sister's daughter, brother's sister, brother's daughter, father's sister daughter, mother's sister daughter, father's brother, mother's brother, father's sister's son, mother's brother's son, mother's sister's son, etc. Next one is beyond Sapinda relationship. Sapinda means of a person connected by the same blood relation. Class 5 of Section 5 of the Act itself provides that the parties to marry should not be Sapinda of each other. Each other means mother's and a father's side, unless the customer usage governing each of them permit of the marriage between two. Thank you. Please like and subscribe. Next video will be on restitution on conjugal rights.